We're back on the air. This is Radio Entrepreneurs. We're heard across the world on the World Wide Web, but you can also find us at radioentrepreneurs.com. You can find our interviews for 45 days. You can also find us on our YouTube channel, snippets from our interviews. Our next guest, a serial guest, but in a different coat this time. We have Joseph Cote from Navy Yard IP, and today we're going to talk about the American Invents Act, correct?
America Invents Act.
Yes.
AIA, commonly referred to.
Yeah, well, and then we're going to get into some other things because there's a lot of layers to you.
Yep.
So tell us about AIA.
Well, AIA came out a few years ago by Congress adjusting the patent system for the first time in about 30 years because things had gone along for a while and a lot of technology had been created. There were some bad patents out there, and there was a lot of litigation happening. So they wanted to try and readjust the whole patent system. And so they created all these regulations, put them together in an act, and it came out. But unfortunately, it wasn't a done deal. It wasn't completely tied up together in a nice bow. And there have been changes required. There are people in Congress trying to change because of patent trolls and what they've done. And I've been in the patent business almost 30 years now. I started out as running patent operations for GTE Laboratory in Waltham, Rockwell Scientific on the West Coast, been a founder of one of the premier patent litigation assistant firms on the West Coast, IP Value. So I've been around it a while, and what I think is it's a very difficult thing when you've got a very technical subject being managed by a very political system. And I don't think it's being done totally to the best interests of inventors. And I'm talking about the sole inventor, the guy who's out there paying his own buck to get his patent, gets his patent, and then tries to say, okay, now what do I do with it? How do I get this thing commercialized? And there's very little in this country to help him.
Well, what was wrong with the old system?
The old system was being managed by the big companies for a time. And there became two outposts. One was high technology, the wireless, the mobile, the computers. All those are one type of technology. And then there's pharma, which is a very different type of technology. And you've seen a lot of litigation in the wireless area, Samsung suing Apple, Apple suing IBM, IBM suing the world.
I just see a lot of happy lawyers in all this.
I mean,
It is.
really.
It has really turned into litigation. 30 years ago,
Look at Peter, he's smiling.
It's the lawyer's
Dream.
retirement fund.
Full Employment Act.
Yeah.
The Lawyers Full Employment Act,
Right.
yes.
And it has really shifted away from the technology into the legal manipulations of a court case. And
So how is AIA? What are the
America Invents Act. And
Okay.
it did certain things which were good for the U.S. and the world. It made it so the first to file is the one that gets the patent, not the first to invent. The U.S. was the last one to change that rule. And they did it to be compatible with the rest of the world.
Isn't there a lot of logic to that?
There is.
First to file,
Okay.
and that
But
it's universal?
it wouldn't have worked for Alexander Graham Bell, who actually,
Well, if he was working under a different set of rules, he might have done it.
well, again, it's the rules. And every
Right.
country manages how their patents are done.
He had no rules. He just invented, right?
Well, he did have rules, and he got to the patent office first to get his stake in the ground to show that he was the first to invent.
Right.
Okay? But what's happening now is you've got people, who is a patent troll in general? Anybody who sues you for their patents, saying that you're infringing.
But not everybody can sue for patents. You have to have a lot of money to sue for patents.
Well, you
have to
need
be
a
able to
lot of
protect
money
yourself,
to be able
too.
to sue.
If
Yes.
Microsoft decides to use someone's patent and someone's basically got a startup, you've got to have the horsepower to not just defend it, but to win.
Right. Without naming names, there was a very large company 20 years ago that was in medical products. And rather than invent their own technology, they used what was in the marketplace and just expanded on it. And essentially told the industry, I'm big enough that if you think you can survive taking me to court, I've got lawyers I can put on this for 5 years. I can outlast you.